Good afternoon. Can you hear me okay?
Yes, I can, Your Honor. It's a pleasure to be before you.
Thank you. Are we going to have a witness or just going to be your presentation today?
It's probably just my presentation, but my client, who I always think should attend hearings, was going to try, it's Miss Athena Adams, was going to try to attend, and then the case manager assigned this into her office. Miss Hannah Cube is available too, if we needed witnesses for any particular matter.
Okay. Why don't we go on and proceed, and we'll add them as they show up if we needed to, okay?
Yes, sir, Your Honor.
Okay, we're here on cause number DC 22-13588, Tenfold versus JM et al. This is a motion for a default judgment. You may proceed.
Yes, sir, Your Honor. I think that the time frames are pretty well laid out in our motions, but to provide some context, JM Roofing and Constructions and Mr. Jim Ed McNally's are operate a purported roofing company. He apparently, we've come to learn, is a felon for fraud. He was recently released in the last 4 years from federal prison, and after his release, put together a roofing company. The roofing company would then solicit investors, promise, oh, there's Miss Adams, and promised, by the way, this is my client, Miss Adams, who just joined us, and they would solicit investments from different people in order to fund commercial roofing projects with the promise of high interest yields paid monthly and total payment once the purported insurance paid out. We've also come to find that there's a few other cases that have been filed, and apparently there was an individual by the name of Arian Baker, among others, who would solicit groups to contribute to the building. And so in our particular case, Tenfold Enterprises, which is owned by Roderick and Athena Adams, husband and wife. Mr. Adams is a firefighter here in DFW, and Miss Adams is a teacher. They, both individually and under their company, made substantial investments, and the amount that they paid, which is well in excess of $250,000, had it been paid back as an investment, would have come to $708,000 in monies that were due and owed, still are. We filed this petition. We obtained service on all parties with respect to Arian Baker. Arian Baker is both the managing member and what her company was served, A Consultants LLC, through the registered agent. But we have been unable to get personal service on Arian Baker, so the motion for default judgment is exclusive to the other defendants. We also sent a DTPA demand letter at the time prior to filing the case. However, the time frames for getting the triple damages did not run until the, I believe, the very end of January. And so that letter was then, was never replied to, but we amended our petition to include the treble damages and DTPA claims more than 20 days ago and sought to deliver it on all the parties. So we're asking today that a order be entered for a judgment against the all parties except for Arian Baker in the amount of $2,125,500. So $2,125,500. That includes the actual cost as well in the request for the attorney's fee.
Can you hold for 1 second? I'm sorry.
Yes, of course, Your Honor.
This is Judge Hurdle. May I help you? Hey, Becky, I'm in a hearing right now. Can I call you right back? All right. Thank you. Bye. Sorry about that. Go ahead.
No, of course. And so we would like this to be signed. Also, we think that Ms. Baker is going to ultimately be found. We put in there very thorough notes. We've sought to serve her at multiple locations. We intend on urging this default judgment against her once a potential motion for alternative service is granted, and whatever requirements under that motion for alternative service has been met. And that motion's been filed. It's pending before the court, but has yet to be granted. And so I hope to be back before you in the near future when it's the appropriate time.
Okay, I've got a couple of questions. I have read this, as I mentioned to you in my email. I show that you served Mr. Canales by serving his wife. Is that correct?
Yes, Your Honor. We served his wife at the property address that I believe they both live at. It's interesting that you bring that up too. He had claimed he was in the hospital for a bit. We went back there as well to try to serve him again. He has family members that live next door. Presently, that house purports to now be not occupied.
Okay. Did you obtain a motion for subservice?
No, Your Honor. His wife was over the age of 18 and at the property in which he claimed to live at, and so that was the, so we served them as an adult at the property.
What's your authority that you can serve the wife of a defendant?
Code requires that that we can serve a, 1 second. Is it Miss Jackson's wife as well? Yeah, Miss Jackson's the other defendant, that's his wife.
I understand that.
Your Honor.
I understand that.
But
my question specifically is, where is your authority that you can serve a wife of a defendant without an order on a substitute service?
Oh, I believe that the code only requires serving an individual over the age of 18 at the property in which they reside. She also clearly identified herself, said that he lived there, and then accepted service on his behalf. And that's in the affidavit that was provided by the servicing agent, Mr. Winrow.
I understand what you're telling me, but I guess you haven't heard my question. Where is your authority that you can serve the wife of a defendant outside an order for substitute service?
It's in the code, Your Honor. In Texas Rules.
Okay, where is cite?
I'm happy to go get it if I can find the exact line.
Cite that for me.
Sure.
I'll get my code book as well.
Yes, sir. It's Rule 106, but that doesn't say it expressly about the, it's interesting though. I'm reading it, just where I'm reading it, Your Honor. It says amended, as amended through January 27, 2023. Recent amendment that allowed, because we thought about this, it allowed, they revised it in response to 17.033 of the Civil Practice and Remedies Code, which allows now for citation by social media. And so I was fairly surprised by that and considered doing that as well at the time.
Okay, let me tell you where I'm going with this, okay? You can serve someone over 18, and you can serve someone with through social media, but that's through an order of the court supported by an affidavit. So as I understand, having read this, looks like even though she is a defendant, she's not an appropriate person to serve another defendant, even if she's his wife. So I don't think I can grant you a default judgment against her.
You mean him?
Against him, that's correct, because
Yes,
he
sir,
was
Your Honor.
not personally served. Now, I can't grant you the default regarding the other three defendants, because I do show that looks like JM was served through an agent, personal registered agent. Mr. Bill was personally served. Ms. Jackson was personally served. So I show service to be appropriate to those three defendants, but I guess it's my ruling that Mr. McCallus cannot be properly served through his wife, and because he's not been personally served, I can't grant a default judgment against him.
Okay, Your Honor. If I find additional information that would supplant this, is it appropriate to refile only specifically on Mr. McNally's?
Well, if you find something that goes against 106, where you have to have a court order to show to serve,
Yeah.
if you
No,
find that,
looking
you're
at
more
it-
than welcome to do that. I haven't seen that done yet, but
No, I'm a little embarrassed. I have an incredibly experienced litigation manager who's out of office today. His family member's got pancreatic cancer, so he's in Shreveport at a thing for him. And he doesn't make so many mistakes that I double check his work enough probably. And so I wanted to make sure I mentioned it just in case there was something I was missing. But I appreciate it. Thank you for pointing that out to me, Your
if
Honor.
you find that for some reason that is good service, and you want to amend your default judgment, I will consider that, but I have to have some good authority on that. But
Yes, sir.
I'm prepared to offer the default for the failure response for the other three defendants. Now, you mentioned you're asking for, I think the amount was $2,125,500.
Yes, sir. The amount due and owing was $708,500, and we just used the triple damages model.
Can you break out those damages by each element and provide the evidence for each of those for me, please?
Yes, sir, Your Honor. The initial amount, find it, it's written in the primary petition. So we have that breakdown. You just pulled it from the amended petition. Sure. I know it's in the order as well, but I wanted it a little more specific. Just a little bit. Okay. And so okay. Initially, Your Honor, we have the total amount of $377,000.
And what is that? What was that?
Yes, Your Honor. That was the amount that Mr. Make sure I'm getting it right. Mr. Adams, Roderick Adams, was supposed to receive back from the defendants after having.
You broke up there. I'm sorry. Say that again. Can you repeat yourself for me, please?
Yes, sir, Your Honor. That amount is the amount Mr. Roderick Adams was supposed to receive back, including his interest in exchange for the amount of money that he tendered to the defendants. So it does in fact include the interest had it been paid. The amount that he paid was more, I believe it was approximately, Ms. Adams is on here, but I think it was approximately $200,000. And then
let me do it this way. Let me ask the question. How much was invested in this group?
I believe that it was two separate loans, so I'm trying to get it right. $250,000 was invested. The amount they were supposed to receive after interest and payments was $708,500.
So there were two investments. Maybe we should get some testimony from. Is it Athena?
Yeah, sure.
Yeah. Let me ask her a couple of questions. Okay.
Hello.
How you
Yes.
doing? Can I
I'm
get
good.
you?
How are you?
I'm fine. Can I get you to raise your right hand for me, please? Okay, do you solemnly swear or affirm that the information and the testimony you're about to give is true and correct to the best of your knowledge?
Yes.
Okay. Just a couple of quick questions for you. Or do you want to conduct this, Mr. Hilton?
No, it's okay.
Okay.
And it starts on page 8, Your Honor, of our amended petition.
Okay.
The breakdown.
Okay. How much did you and your husband initially invest with these individuals or this particular project?
In total, I mean, I'm not good with exact numbers, but it was a little over $200,000.
Okay, can you be more specific? Was it, you said a little over, is it 210, 2.5?
Somewhere around 225 to.
Okay. And that was your total outlay into the project was about $225,000?
Correct.
Okay. And what's your understanding of what that should have returned to you?
So my understanding, and it was happening in increments, was supposed to be 60% of returns every single time we made an investment. So it was basically recurring transactions. So we split the investments up into 2 separate parts. So for example, 100 and something thousand here, 100 and something thousand there. They were on recurring. They were on recurring payments. So basically, if we put $100,000 in, we're supposed to get 60% back. That 6%, instead of pulling it out, we let them continuously hold it, and we signed another contract. That money then turned into another 60% over and over and over and over with 2 different transactions by the end of everything. And it's hard to explain, but we have all the contracts. We've submitted all those things to Mr. Health. I can't pronounce his name. I'm sorry. I have a hard time. Yeah, yes.
And I'm reading it right here too. So, Your Honor, to clarify what you're saying, because they did get the returns initially, they would go reinvest the new principal amount, which they actually paid in $226,000, and then, but by the time they would reinvest it, that $226,000 was over $300 on the reinvestment because of the potential 60% return. Right? They did that twice.
Yes.
So basically, you invested $226,000. You were guaranteed a periodic payout of about 60%. Is that correct?
Correct.
And that was over what what period? How long was that? Was that a year, 6 months, 2 months, 3 months?
This whole process lasted about 8 or 9 months. So, and again, this is our mistake, hindsight, of course. Instead of pulling those investments out, so we never actually got that initial $200-something thousand back. We were given another contract. They held that money, and then we were given another contract that said, now your $300-something thousand investment is going to be, increased by another 60%. So it just kept rolling and rolling and rolling until it finally came to a halt. And when it came to a halt, we were supposed to receive $700 and some odd thousand back.
You know how much specifically you were supposed to? Did they present you with a document that showed what that was going to return by reinvesting the interest back into the project?
Yes, we have final documents for both. We have 2 separate transactions running. We had a final document for both and an email, and all that has been submitted. And but of course, that all communication ceased. We have no way of speaking to him, finding him, so.
Okay, but
Yeah,
I
but we
guess
did
my
have
question,
documentation.
I'm trying to determine these numbers. I guess my question is, did they give you said when you reinvested your initial $250,000, they said they were going to pay you 60%, and that was going to be paid out on a monthly basis?
That's every 60 days.
Every
So
60 days. So instead of you taking out that 60%, you reinvested that back into the project, correct?
Correct.
And
we were given a new contract each time.
And you did that for a period of 8 to 9 months.
Correct.
Okay. All right. And can you tell me how you said the $700,000?
Yes. So the 2 investments, one one resulted in about 300 and something thousand, and the other one ended at about 400 and something thousand.
Okay, I'm trying to determine damages I want to award you, so I need to be more specific. I need to hear it from her first. If you need to step in, that's fine. Could you be more specific with your answers for me?
Okay.
You said one was 300 and some thousand. I mean, you don't have to give me exact penny. I'll let your attorney kind of fill in the gaps, but I need to kind of hear from you.
If I wish I had my notebook because I have everything written down so specifically. But one is around $335,000, and the other one is about 400 and I want to say 450, 400 and I hate that I don't have the exact numbers, but it's about 768 is the number that is coming up in my head.
Okay.
Something 700 and something thousand. Yeah,
Okay.
about that.
And any other damages that you may sustain by this project that you can recall at this point for me?
Damages, financially. I mean, I've had to go back to work. I was initially, my husband and I, on aside of being, you know, a fireman and a school teacher, I had actually retired from the school district because we got into real estate, and that's what we have been doing. And I have a lot of rental properties that I manage, and that's the money that our hard-earned money that I've been working the last 4 years for. We invested it in this project, and now our rental properties are drowning. I've had to go back to work. It has taken a complete toll on my family, mentally, spiritually, like everything. We can't believe we got ourselves into this situation. My husband is beating himself up because he cannot believe that he trusted this man. And he considered himself a smart businessman. And I mean, he went to dinner with this guy. He looked him in his eye. You know, he made us feel like we were his top investors. We didn't even know that other people were involved in this. We didn't know how big this had gotten. We had no clue that this man was such a scam artist. And we're both beating ourselves up because we don't know how we got ourselves into this hole. We don't want to have to sell our home. We don't want to have to, you know, give up our things. It's a complete mess.
Were there other investors in this project as well that you're aware of?
We were aware of the project from my brother-in-law, and he was the one that kind of told us about the project. And other than that, we didn't find out about other people that we kind of knew were involved until after. It was kind of one of those things, like, I think everyone thought that they had kind of come up on something and nobody was really talking about it too much. It's almost like when you got something good, you don't, you know, kind of blab about it too much. So only people we really knew was his brother and my sister-in-law.
Did they invest in this project as well, or just were aware of it?
They invested in the project prior to us.
Do you know if they received any kind of proceeds from the investment during the period of time they were investing in it?
So yes, they received the proceeds in the beginning, and that's what made us want to go into this, because we trusted it. It was kind of, and now that looking back, that was part of his, I think, plan to kind of give you your money back a little bit at a time to make you trust the process, and then when you're deep in it, he just flees. So they got their money back, a small investment. We were like, okay, this is legit. This is a good move. And then their second time investing was after we had already invested. So we invested, and then they invested their second time, and then they were supposed to close on their home, and he stopped communicating with them. So they couldn't close on their home for about 2 months late, and then they had to go. Their interest rate went up. They didn't have any funds, and then my brother-in-law finally, after calling him and just really like harping on it hard, he finally gave them the money, and they were able to close on their home. And then that's when we started getting worried, because that's when the communication with him started to go away for us as well.
So did your brother-in-law get the return on his investment in the same project that you guys did not get your return?
My brother-in-law, he just got his initial investment back. He didn't get his interest. He was just like, just give me something so I can close on my home. Give me my money back. And so that's what he got back. He got his money back.
Okay, Mr. Otoski, you have any questions of her?
No, I did want to point out though, and ask perhaps if my client, if Ms. Adams, if it refreshed her memory. In the last 2 pages of Exhibit F in our amended petition,
Let me pull that up. Let me pull it up.
Yes, sir.
When was that filed?
The amended petition was filed, this one's not filed yet. Oh, you have the doc, okay, that's fantastic. I have the amended one, right? You have the original. On January 10th, 2023, Your Honor. And we did a really good job on this one. So like.
Okay, I have it up. And you're referring to which exhibit again?
Exhibit F and G will be the ones I'll draw your attention to.
Okay.
And
give me a second. Give me a second. Let me pull them up.
Yes, sir.
The computer's kind of slow. Exhibit F and G?
Yes, sir. And it's the last 2 pages of Exhibit F.
Okay, give me a second here. Getting there. Okay, I've got F up. Okay, which page now?
The last 2 pages of that exhibit, but you can see that it's an agreement, effectively, between the parties that was drafted by Mr. McNally's and his company. And on the second to last page, it says that the payout will be $377,000, which includes the principal loan amount of $232,000. This was one of the last 2 deals. And if you go to G, it has on page 4 of G, it has a similar agreement that has the $331,500 that Ms. Adams was right on about, and the initial funds of $204. And so as to be genuine with the court, both of these are one of the roles of the 2 investments, which is why the initial amount is more than the actual money that Ms. Adams stated earlier, because it should have already grown.
So basically, you invested $225,000 in two separate times. The first time you were guaranteed a payout of $377,000. The second time you were guaranteed a payout of $331,000. Is that accurate?
Correct.
And I'll differentiate on that, Your Honor. Ms. Adams did one of these was smaller than the other at the beginning and was done by Ms. Adams separately. Then Mr. Adams, the competitive man that he is, knowing his brother was involved, went in and did a second one that was higher, which is why, as those 2 separate deals run through, we actually have those 2 added together because they never received
I understand that. I'm just saying that.
Yes, sir.
You referred to Exhibit F as 377 and G as 331, right?
Yes, sir, Your Honor.
Okay.
And that's where we came up with the $708,500.
Okay. All right. And so that's your actual damages.
Yes, sir, Your Honor.
Okay.
And we're at $9,280 in costs and attorney's fees.
982.
9,280. It's in my affidavit and in the proposed order.
Okay. And what other damages?
We have attached to both the petition and the demand letter that we had sent, and it sat the necessary time under the code, which is one of the reasons we amended the petition in January. At that point, we added that, and we utilized that to multiply the actual damages only to reach the $2,125,500, $2,125,500 number.
Okay, let me hear your evidence that this is a violation of the DTPA.
Sure, Your Honor. We would argue that that among many things, that they were in the business of helping folks to invest, that they promised a certain return. The return was likely never contemplated to actually occur, so it's beyond that, it's fraud. But regardless, as a result of that, we sent the demand letter. It sat for 60 days. We received no response. And we don't have anything to show medical damages. So while there was clearly pain and anguish, we limited the amount to the monetary damages in order to get the treble damage triple amount.
Well, let me ask you this. Your client just said that some people did get returns back from this investment, right?
The only thing that we're aware of is the principal amount. It was the down payment for the home he was buying. It was approximately $40,000 to $60,000, brother. And that's the only person that we're aware of that did get a return back. And after that, we really haven't spoken to anybody else.
Okay, any other damages?
Just the attorney's fees, Your Honor.
Okay, sir, you're asking for $377,000 and $331,500 based upon the initial investments and the proposed return. $9,280 for attorney's fees?
Yes, sir, Your Honor. And cost. Some of that is the
What's your
cost for the some of that is the cost for the service, the filing.
Okay, what's your cost? What's your cost?
Gosh, it's high on this one because of all the service. Hannah, do you happen to know the breakdown of the cost for the service? Would you think it's in Cleo? It's in the verified motion. Okay, sure. Yeah. Oh, there it is, the receipts. So we're at $8,000 in attorney's fees and $1,216.95. And in hard costs, that includes $446.95 for filing and issuance fees paid, and $770 in payments for the service.
Okay, have you sent a proposed order?
Yes, Your Honor, we sent proposed orders and it's on file already.
Okay, let me make sure I have it.
Yeah. And in the proposed order, it shows the damage breakdown, though it didn't expressly pull out the $780,000.
Okay, what I'd like for you to do is resubmit your order.
Sir?
And redact Mr. Canales.
Yes,
I
sir.
feel like there's been appropriate service on him, and I can't award a default judgment without the appropriate service. There's no jurisdiction. And if you will, include lines for the actual damages, the attorney's fees and the cost, and any other damages that you feel are appropriate. I will say at this point, I do not see an indication or enough evidence to show that there's a DTPA violation.
Okay.
You're more than welcome to submit that with your order. I'll reconsider it, but at this point, I don't think there was enough evidence presented to show that there would have been damages as a result of that. So resubmit your order, and I will get it done today, and it should be available to you for the end of the week.
Yes, Your Honor. I don't know if you had an opportunity to look. We broke out the actual liquidated damages. What we said was that at the time was the $2,125,500, and then the attorney's fees for $92.16. Would you like both of those broken down more specifically, sir?
I think I put up the order to retain. Let me put up the wrong order. Yeah, I need I need to have all the damages broken out for the event that this default is overturned, as you know. So
yeah.
Instead of having one lump sum, it's okay for actual damages, but if you're going to break out attorney's fees, you're going to break out cost. those have to be broken out separately.
Yes, sir, Your Honor. And are you concerned about their indicator as a consumer in regards to the DTPA?
Well, you've made a lot of allegations, and this is my issue here.
Yes, sir.
Obviously, this client did not get her returns, but I don't know if there's enough evidence to show that there was fraud, that there were violations. Obviously, somebody got paid.
Would it help if
Wait,
we
can I
pointed out
finish?
that-
Can I finish first? Okay.
Yes, sir. Sorry about that.
And that's why I was asking her some questions about the other investments. Of course, this is a default judgment, but I've got to look at some credible evidence. And fraud, you have to kind of indicate some kind of intent. And we don't have any information in the record. Of course, we don't have a record, but we don't have any evidence here of their intent to actually defraud your clients. We know that they invested money and they were promised some money that they didn't get, and they're entitled to that. But I don't see enough evidence in what you presented to indicate that there was some fraud. I don't see enough evidence in what you presented to show that there was a DTPA violation.
Would it be appropriate, Your Honor, for me to put in here that the order was issued, but I'm not prejudiced to proceeding forward on the DTPA claim?
Well, what you can do, if you want to hold off, you can submit the order later. I mean, that's your decision. I mean,
Man, don't you always take what you can get, right?
Well, I'm prepared to hear this today, and I've told you what my rulings are going to be. If you feel like you've been adversely affected by that and you want to submit it later, you're more than welcome to do that. Now, of course, you run the risk of somebody winding up filing an answer and you don't get the default at all, but that's your decision. But at this point, I'm not prepared to award any damages as a result of fraud or DTPA.
Appreciate you, Your Honor. Thank you so much, and we'll do as we were told.
You said what?
Thank you very much, Your Honor. I appreciate you very much. I have a feeling we'll be submitting that order quickly and then proceed forward from there with the other defendant.
And if you get the other defendant served and they don't answer, then you may be able to recover some of that. If you can present some evidence of these issues, the mere fact that you plead these is not enough. I still have to have credible evidence to award the damages, and that's why we have to have this hearing. So if you want to proceed against the other defendants and seek those causes of action as well, I think you'd be wise to kind of present more evidence which kind of substantiates that allegation.
Sure. We have it. There's other judgments, and they're both felons. I just got to get it on file. So I will take that information. By the way, Your Honor, it's so nice to be before you, and I hope to see you. I do a lot of foreclosure litigation, TRO stuff, so I'm sure that I'll have a pleasure.
I see a lot of those.
Yes,
Okay,
sir.
well, thank you very much, and thank you, Ms. Adams, and I hope you've had your day in court, and I'm sorry this has happened to you, and I hope this will help you to recover. And Mr. Hiltoski, I'll look for your order, and if you want to proceed on those other defendants, just kind of move forward on that, and I'll be looking forward to dealing with that as well.
We're going to keep it up. Yes, sir.
All right. Thank you very much. You ought to be dismissed.
Thank you.
believe I thought you said about white. Hi, Becky. This is Ron Hurdle. I'm sorry, I was in a hearing when you called. I couldn't get out. Okay. Okay, I was able to find a trust document that created the Marion Butts Family Trust. It was set up on December the 2nd of 1982. Is that the document you're looking for? Yeah, that's his trust. Now, it's kind of lengthy. I thought about scanning it, but it's the old document that's got about 8.5 by 11 sheets of paper. So, no. Yeah, you're on the other side of it. What I can do, I can probably scan it in tonight at home and then email it to you. Okay. Okay, I'll do that. If that's not the right thing, you can let me know. Where are we on getting this thing done, you think? Okay. All right, Becky. Well, I'll scan it tonight at home and I'll email it to you in the morning. Thank you. Bye-bye. Bye.